Transmissions from Hawaii.
It's interesting that everything that I do has been informed and driven by being trained as an officer by the United States.
Mm-hmm.
That's the irony of all ironies. Because I don't dislike the United States,
Yeah.
not even. It's just that this isn't the United States. This is the Hawaiian Kingdom.
Yeah. That is the voice of Dr. Keanu Sai. He served in the U.S. Army from 1984 to 1994. He also has a PhD in political science.
So I'm a lecturer at the University of Hawaii in political science and Hawaiian studies out of Windward Community College. But I'm also an affiliate faculty member at the College of Education, the graduate program.
However, aside from being an educator, Dr. Sai is also a government official. That's because he is the chairman of the Council of Regency of the acting government of the Hawaiian Kingdom. So how many people are in the Council of Regency?
4. So under Hawaiian Kingdom law, the cabinet of the monarch can become a regency in the absence of a monarch. So Queen Lili'uokalani died in 1917. So the office is there, but the person is not, the individual, right?
Mm-hmm.
So under Hawaiian law, the cabinet council made up of the Minister of Foreign Affairs, the Minister of Finance, the Minister of the Interior, and the Attorney General.
Mm-hmm.
Collectively can become a council of regency, which serves in the absence of a monarch. And that's how we represented the Hawaiian Kingdom at the Permanent Court of Arbitration. Now, under Hawaiian law, these ministers are supposed to be appointed by the monarch. So how did we become ministers? And that's called the doctrine of necessity, assuming the chain of command within a command structure. And that's why it's called the acting council of regency.
As we discussed in our previous episode, the government of the Hawaiian Kingdom was overthrown in 1893, but that doesn't mean that it simply disappeared. In fact, in 2001, the Permanent Court of Arbitration in The Hague in the Netherlands verified that the Hawaiian Kingdom continues to exist. My name is Tony Vega, and welcome to Transmissions from Hawaii. In this final installment of our 3-part miniseries called Insurrection, we're going to learn about how it was that a court case about traffic violations on Hawaii Island eventually led to the oldest institution in the world for settling international disputes, confirming that Hawaii was never lawfully incorporated into the United States. This is the story of Larsen versus the Hawaiian Kingdom. Here to share this story with us is one of the individuals who was at the center of it, Dr. Keanu Sai. But before we talk about the case, let's begin with Dr. Sai's time in the Army.
Back in 1992, I began to do some research regarding my family genealogy. And it naturally took me into the kingdom era. And what I began to realize is that what I had learned going to high school at commitment schools, as well as at the University of Hawaii, it was all wrong. What actually informed me on what happened regarding Hawaii was my experience that I had as a field artillery officer. I was a captain in 1990 at Fort Sill, Oklahoma. That's where I was going through officers advanced course. And this is when Desert Storm happened, when Iraq invaded Kuwait. When I was up there, it was still called Desert Shield. It didn't get to Desert Storm to expel the Iraqis. But during that time, we were very well aware of what happened to Kuwait. And we were basically preparing battle plans. And that was part of the training that I was going through. And we knew, but I didn't know it as a political scientist. I knew it as a grunt, as a military guy, that what Saddam Hussein overthrew in Kuwait was the Kuwaiti government, not Kuwait, the country. And that forced the Kuwaiti government to flee into exile and establish themselves in Riyadh in Saudi Arabia. So even though the government was overthrown, we knew Kuwait was still Kuwait, and that Saddam Hussein was obligated to administer temporarily the laws of Kuwait until there's a peace treaty. between Kuwait and Iraq. But Saddam Hussein didn't do that. He was treating Kuwait as if it was a part of Iraq. And then later, let's say about a month later after they invaded, he unilaterally declared by Iraqi law that Kuwait was annexed and that it became a province of Iraq. We knew that all of that was illegal and it had no standing. And our job was preparing to repel or eject the Iraqis out of Kuwait so the Kuwaiti government can come back. So when I'm going through this officer's advanced course, we're getting live intel coming in and we're all preparing. When I got back home, because I was in the Hawaii Army National Guard as an officer, so that was part of my training. When I got home, 2 years later, I began to look up my genealogy more for family reasons. And my family goes back to the original days of Native Hawaiians here in Hawaii. Okay, that's a main line of mine. In fact, my fourth great grandfather, Kanaina Nui, was the one who killed Captain Cook. Okay, so kind of gives you a sense of the line of my family. Now, in this research, I also found out that what happened in Hawaii was precisely the same thing that happened in Kuwait, done by the Iraqis. That what happened with the overthrow in 1893, it wasn't an overthrow of the Hawaiian Kingdom as a country, it was an overthrow of the government, which President Cleveland, after an 11-month investigation, concluded it was illegal and that he vowed to restore that government. But it had nothing to do with the country. The country was still there, right? And then 5 years later, after Cleveland was unable to restore the Queen to this constitutional monarchy, this form of government, because of political wrangling going on in the Congress, he was replaced by President McKinley, and it was McKinley that unilaterally annexed Hawaii by signing what is called a joint resolution passed by Congress. So the House and Senate agreed jointly, that's why it's called a joint resolution, to annex the Hawaiian Islands at the height of the Spanish-American War. And then he signed it into law. To me, it was like, wait a minute, that's exactly what Saddam Hussein did. What's the difference? And we still looked at Kuwait as if it was occupied. Well, my conclusion that I came to, which I couldn't refute, was the fact that Hawaii was never part of the United States, even though it was treated like it was, just like Iraq with Kuwait. Iraq's occupation of Kuwait lasted, I believe it was 7 months. Here, this was prolonged. I mean, it's over a century. And information has been used in disinforming people. So that's where denationalization, I began to realize, took place in the early 1900s, which is my grandparents' generation, where they were led to believe that they were American citizens, that Hawaii was a part of the United States, and they had to speak English. And if they didn't speak English and they speak the national language, Hawaiian, they get beaten. We hear those stories. Right. Well, by the time that information got to my dad, he was born in 1939. It's already institutionalized. He didn't know anything about the Hawaiian Kingdom. And by the time it got to my generation, I didn't know anything. So when I came to that realization that Hawaii is not part of the United States, it was like looking at a movie that I saw in the past called The Matrix. And that sci-fi movie, if you're still plugged into the Matrix, you're living a fantasy, but you got to get unplugged, right? You got to take the blue pill. You might say, I took the blue pill and everybody else is still plugged in. And that's where this guy, Donald Weil, he's a British novelist. He once wrote, when a well-packaged web of lies has been gradually sold to the masses over generations, the truth will seem utterly preposterous and its speaker a raving lunatic. That is exactly how I felt when I woke up, because everybody did not believe what I was saying. And I was trying to explain to them what I found. Nobody could believe it. So we knew that we had to deal with denationalization. Denationalization is, by definition, obliteration of the national consciousness in the minds of an occupied people. It's actually a war crime. That's what Germans were doing in occupied France, called Germanization. Italians were doing that in Yugoslavia during World War II, called Italianization. What we got here is Americanization. And what hit me was I was in the American military. And I was like, what the hell? It was like getting hit upside your head. And you're just waking up like, wait a minute, is this true?
Right.
And that only got me to dig further, to go deeper, because as an officer, I was very well trained, and we were trained to be very vigilant. We're trained to be to have attention to detail, right? Seize the objective, make a course correction with appropriate intel, right? That was all ingrained in us. Good management skills for crisis management. And here I'm looking at a crisis here in Hawaii. So when I looked at this, I realized that, okay, international law, I know, separates the government from the state. And our government was overthrown, but our state wasn't, because you can't overthrow a country, right? And that's what it's like, a nation state. So I began to look at other examples in the past similar to us. And I found a few examples in World War II. When Germany occupied Belgium, they captured King Leopold. Belgium was a constitutional monarchy. And I began to see some similarities with their system of government as a constitutional monarchy and Hawaii's, because Hawaii had the same status. We were a recognized independent state, no different than Belgium and Germany. In fact, the Hawaiian Kingdom had a treaty with Belgium, in the 1800s. So we were co-equal. So when I looked at that situation and others, there was a provision in the Belgian constitution where when the king is absent from the throne, a regency serves in the absence of that monarch. And that's what got me to think, wait a minute, we have a provision in the Hawaiian Constitution for regency as well, Article 33. And basically what I did was I said, okay, this is what we need to do. In my mind, we got to restore the government, like a government in exile, but we're going to do a government restored here in our country. And that's when in 1996, we formed the Council of Regency under what is called the doctrine of necessity. That's why it's called the acting government, right? Just like a private can become a lieutenant in time of war if everyone in his chain of command is killed, but it is up to that private to assume the chain of command and become that acting lieutenant in order to maintain the command structure. We knew that. I knew that. Well, we're going to do the same thing that the Belgians did. We're going to do it because it's not going to be drawn on racial lines. I'm not looking at this as a native. I'm looking at this as a national of a country who just woke up from over 100 years of being brainwashed. That's what I saw. So once we restored that Council of Regency under Hawaiian law, in a very unique way, but legal, we came up with a strategic plan. And that strategic plan was basically 3 phases. First phase, verification of Hawaii as an independent state. Notice I didn't say recognition. It says verification because we were a recognized state and we still are. But we need some entity, some reputable body at the international level to verify. Once we get verification, then we move to exposure. Expose the occupation. Exposure of Hawaii statehood within the framework of occupation. Economically, politically, legally. And then naturally, phase 2 would trigger phase 3, which is when the occupation will ultimately come to an end. Now, phase 2 is important, exposure, because what we have here is we have the non-compliance of over a century of international law, non-compliance, because the law of occupation obligates the occupier to administer the laws of the Hawaiian Kingdom, not American law. Just like in Iraq, international law mandated Saddam Hussein to administer Kuwaiti law during that occupation, not Iraqi law. And the imposition of Iraqi law within Kuwait is considered the war crime of usurpation of sovereignty. Well, that's what we got in Hawaii. The problem here, though, is all the insurgents are dead, the ones who were responsible for that. And that through denationalization over the years, basically everybody's a victim of the war crime of denationalization, where we unknowingly stepped into the shoes of insurgents because we're led to believe a lie. I mean, this is truly the Matrix movie. That's why when I saw that Matrix movie, I said, that's the script for Hawaii right there. And that's science fiction.
Right.
This is real,
Right.
you know? So here we are dealing with the situation, and we have to begin to expose it, because we have to show people that this is not about sovereignty. This is not a sovereignty movement. We are not trying to become a country. We're not trying to become a federally recognized tribe, whatever these different groups are wanting back then until today. We're dealing with a country already established, and sovereignty is in the country. It's not in our people. And that country still exists. And that's where our rights are. So that's what started exposing. So in 1996, we're going to expose it by addressing something that nobody can dispute, and that's called land titles. Because in 1893, land titles in Hawaii could not be transferred. And the reason is very simply, who's the notary? Who's the notary after January 17th, 1893? Well, that notary or notaries were insurgents. And President Cleveland notified the Congress, and he concluded that these insurgents, calling themselves the provisional government, owe their existence to an armed invasion by the United States. That means that's a criminal. That's an enemy of the kingdom. That notary is invalid. Without a notary, title could not be transferred, because all titles in Hawaii originated formally in 1845. And then you have a Bureau of Conveyances in Hawaii, which still exists today, where you record your deeds, right? So we're going to expose that. And nobody can argue with it, because it's not a political question. It's just a straight up title search. Very simple. Now, the impact that this is going to have is on the title companies here in Hawaii, because when people go in to borrow money and they want to mortgage their property as collateral to secure the repayment of that loan, the bank will not accept the mortgage until they can get title insurance, which would ensure the accuracy of the title search, that what the borrower has is valid. And when that person mortgages it to the bank, and the bank has to foreclose on that property and sell it, they're selling good title. So that's why they require title insurance. So every time a person wants to borrow money, the bank, before loaning the money, says you have to go to escrow. And that's where the title company comes in. Well, the title companies have not been doing a very good title search, because they all should have run into the same thing that I was running into from the public records. It was illegal. And in 1993, the United States Congress and American law apologized for the illegality, acknowledging it was illegal. Well, here it now is tied to land titles. So title insurance, the bank will not accept the mortgage until the borrower purchases title insurance to protect the bank in case something's wrong with the title. Because when the bank loans the money, how are they going to get repayment back? How are they going to cover the debt? Well, if something's wrong with the title, and the title insurance is already issued and escrow closes, title insurance pays off the loan, pays off the full loan. If there's a defect in title that can be proven. And it can easily be proven. Well, back in 1996 until 1998, we were creating a firestorm, and this was called Perfect Title Company. And this title company that I was a part of was exposing this, and we got attacked. And the title company started a soundbite that kept being repeated in the news, that Perfect Title are telling elderly people don't pay their mortgage. That's crazy. First of all, you don't pay a mortgage. You pay a loan secured by a mortgage. With or without the mortgage, you still owe the money. That's called a loan. But you have title insurance to pay off the loan, which would cover your debt. And that's when it just started to get crazy. And you might say our offices get raided by the Honolulu Police Department. In 1997, we get arrested for racketeering, money laundering, and theft. Yeah, I mean, if you can't break them, smear them. because they couldn't break it.
Yeah.
And now my training as an officer is what's happening here is you're proving me right. Because if this was frivolous, why all the reaction? Right?
Yeah.
We're just doing title reports. And if it is considered fraud, then get us on fraud. Don't get us on racketeering. What is this? Al Capone stuff? Is there a conspiracy?
Right.
Right. So, but I knew the strength of our argument was getting people very, very uncomfortable. So a part of the exposure there was also the exposure traveling around the islands and sharing with people in presentations that the Hawaiian Kingdom still exists and the laws still apply, even though they're over 100 years. And what we have is over 100 years of violation of these laws. To violate the law doesn't mean you made the law legal. No, you didn't. It's just there's a longevity here of violations, right?
Mm-hmm, mm-hmm.
One of the talks that I was giving, and this was on the island of Hawaii at Kiyanosai, outside of Hilo, okay? Mm-hmm. And at this presentation, there was this guy named Lance Larsen. I didn't know him, right? Mm-hmm. But his friend came up to me with Lance and wanted to talk to me after the presentation that I did. And I explained to them that Hawaiian law applies. This is what it is. And here's some law books. So I had Xerox copies from Kinko's, and people were buying them. And all I was doing was buying whatever the cost was to print it. So back then, we didn't really have access to the internet like how we have today. So hard copies, right? So I find out later that this guy, Lance Larsen, looked at the law book. It was a civil code. And there was a section in there, Section 6, that says, the laws are obligatory upon all persons, whether subjects of this kingdom or citizens or subjects of any foreign state, while within the limits of this kingdom. Okay, so that is a section in the civil code. So he, on his own, he looked to see if whether or not driver's licenses was under Hawaiian law. And obviously no, because back in 1893, there were no automobiles, so there were no licenses required to drive a car. Well, that's not his fault, but that's what he saw. And he went, oh. So this is what he did. And I only found this out after. And this was through the proceedings, right? The legal proceedings. That he took off his license plate, and on the back of his Jeep Comanche, his truck, he put a big placard restating Section 6 of the Hawaiian Civil Code. And he jumped in his car and he started driving around Hilo to get a ticket. And he got a lot of tickets. So that was his way of, I guess, civil disobedience, right?
Sure.
Yeah, that wasn't any recommendation on my part. I was telling people follow the law. I wasn't telling anyone to do anything of that sort. But hey, good for him, drawing attention. Yeah. So he ends up getting a lot of tickets, and he goes to court. Now, his attorney is a woman named Ninia Parks. And Ninia Parks contacted me because Lance Larsen told him that he attended one of my talks. And she wanted me to be brought in as an expert witness in his trial in traffic court. And this was going to be in Kiao traffic court. I said, yeah, sure. So I was qualified as an expert by Judge Sandra Schutte because of my knowledge. And the prosecutor could not refute it. So I was admitted as an expert. And I explained to them, there's no treaty between Hawaii and the United States. Hawaii is another country. And that the United States is supposed to administer Hawaiian Kingdom law. And these are the laws. It's not our fault that these laws were not brought up to date. And the prosecutor was stuck because I'm just stating the facts. Right? I mean, how do you argue with it? If he says, well, Hawaii was annexed and became a part of the United States by a congressional legislation, then I remind them, well, congressional laws are limited to U.S. territory. The United States could no more pass a law annexing Hawaii. The United States can pass a law today annexing Canada. They're two separate countries. And they have no effect beyond their own borders, right? That's what it is. So Judge Sandra Schutte, back then, this was, I believe, 1998. She didn't know what to do. she went to her, I guess, her chambers, and everybody just waiting. And then she shows up. Everybody stands. And then she says, I've come to a decision. And I'm watching this play out.
Mhm.
I'm just the expert. I'm just the witness. I'm not part of the case, right?
Yeah.
And she says, Mr. Larsen, I'm going to fine you this much money. I think it was like close to $900 for all the tickets. And she asked him, are you going to pay that? And I remember him stating openly, he said, I'm not going to pay it. You didn't show me the treaty, because if I pay it, I'm committing treason against the Hawaiian Kingdom. And that's when she said, I thought you'd say that. And I'm now ordering you to be incarcerated for 30 days, 7 days solitary confinement. Now, that's pretty drastic for traffic tickets.
Yeah.
But it's the impact of it. Because if Lance Larsen was right and his attorney was correct in making these arguments, then that means she's not a real judge, because she was a judge created under American law. And that she just put people away as well under American law, which is illegal. Can you see the consequences here?
Yeah.
So Miss Parks then turns to me because she is concerned for her client, because she thinks that her client is going to get beaten up in jail. And she doesn't like what's happening. So she turns to me, and then she looks at me, and she doesn't look at me, I wouldn't say in an angry way, but a very concerned, she had a very concerned look on her face. And she said, the Council of Regency is supposed to be protecting Hawaiian subjects like my client. And I said, you're right. We're supposed to. That's our job. But it's the United States that put her away, not us. And we're trying to do this by, like, me serving as an expert witness. She goes, but the council is responsible. Now, in my mind, I'm thinking, you're absolutely correct, because as an officer, we have vicarious liability, right? Well, as a government official, even by necessity, when we took those positions, we carry that vicarious liability. We are responsible for the protection of Hawaiian subjects, period. We knew that. So that meeting or that talk came to an end. I flew back home. She flew back home because we're from Oahu. And then she files a lawsuit, Lance Larsen versus the Hawaiian Kingdom, the United States, and I think the United Nations. And she filed it in federal court in Honolulu. And she was trying to get an habeas corpus. She was trying to get the court to get her client out of prison until this can be resolved by the United States, the United Nations, and the Hawaiian Kingdom, being represented by the Council of Regency. That was her. That was her take. That was her action. Well, she got word that the United Nations filed paperwork claiming they have diplomatic immunity, which they did, and they were removed they were dismissed from the case. And then she also found out that the United States Attorney's Office was going to move to dismiss the case as well, right? So she called us to have a meeting, the Council of Regency. We met, and she explained to us what the situation was. And I said, your allegation that we're liable for this is not true. We're responsible vicariously, but we're not liable, because we're not the ones responsible for administering the laws of the occupied state. And she goes, but my client has rights, and that we accepted. No, absolutely. And I said, well, this is definitely a dispute here, because you're alleging something that we're denying. So with the information you just shared, that the U.S. attorney was about to move to dismiss the case, right, as a defendant, we recommended to her, why don't you remove them off the case to begin with as a defendant? Dismiss them with prejudice, leaving only us on as defendant. And then we will enter into a binding arbitration with you, where we would go to a court that actually has jurisdiction. Because we explained that this federal court is just as illegal as that traffic court that put your client away. They're both created by American law. They're not here under Hawaiian law, and they're not here under the law of occupation. So she agreed. The U.S. was dismissed, and we entered into a binding arbitration agreement to move this case to the Permanent Court of Arbitration in the Netherlands. And that court has jurisdiction because they deal with international disputes. And Judge Samuel King, who was the federal judge at that time, signed off on the stipulation of dismissal and then going to binding arbitration in The Hague. He signed off on it. Mm-hmm. So Nenia, as the plaintiff now, remember, we're the defendants in this case. So this isn't our case. We're defending ourselves. She initiates the arbitration proceedings at the Permanent Court of Arbitration by filing a notice of arbitration with the Permanent Court of Arbitration in The Hague, the Netherlands. Now, the background on the Permanent Court of Arbitration is that it was formed in 1899, established in 1899 as a means to resolve international disputes between countries. And if they cannot resolve the disputes through arbitration, then they can basically go to war and resolve it that way. So the Hague Convention, number one, Pacific Settlement on International Disputes, peaceful settlements, established this court. And if they could not resolve their dispute between states and they go to war, then they would have to use the other Hague conventions that regulate the war, right? So the Permanent Court of Arbitration is not a court it's not an institution that has established tribunals. It's actually an intergovernmental organization, a registry, that facilitates the creation of ad hoc tribunals, depending on what the dispute is between countries. Now, before they can form a tribunal under international law, they need to ensure that the Permanent Court of Arbitration has what is called institutional jurisdiction. What that means is that one of the parties has to be a state, an independent state, a currently existing state. They call it a state, right? Mm-hmm. So we knew that. And the only way that Larsen's counsel could initiate this case is that she's going to have to provide evidence that the Hawaiian Kingdom continues to exist. See, and this is where we're now coming to phase one, right? Verification that the Hawaiian Kingdom exists as an independent state. So she initiated the notice of arbitration. I believe it was November of 1999. Now, I get a call. Well, actually, no, I didn't get a call. I actually called the court, the Permanent Court of Arbitration, to ask on a procedural question, because I was the lead agent. I was representing the legal team for the Consular Regency. So I called the court, and they're like 11 hours ahead at that time. And this must have been February. So we're talking 4 months after the notice of arbitration initiated the proceedings. But no word yet on the creation of the tribunal by the registry. Okay. So I called, just needed clarification on procedural issue. And then I was told that the Secretary General of the Permanent Court of Arbitration wanted to speak to me. And his name was Secretary General Van den Hout. So he gets on the line and he tells me that the Permanent Court of Arbitration can find no evidence that the Hawaiian Kingdom does not exist. Notice how he said that. No evidence that the Hawaiian Kingdom doesn't exist, meaning it exists. Yeah. Because to claim that Hawaii can be annexed by an American law, well, that's the very dispute that we have, is that Lance Larsen, through his counsel, is alleging that the Consular Regency is liable for allowing the unlawful imposition of American law in Hawaii. Well, one of those laws would be the Joint Resolution of Annexation. That's illegal. That's an American law. So here the Permanent Court of Arbitration they're looking for a treaty. And there's no treaty between the Hawaiian Kingdom and the United States whereby the Hawaiian Kingdom joined the United States or transferred its territory. Right. There is none. Okay. And then he tells me that the treaty between the Netherlands and the Hawaiian Kingdom has not been terminated, because there's a provision in that treaty that says how you terminate the treaty. And there has been no notice given by either country to the other of its intention to terminate the treaty. It was a treaty of friendship and commerce and navigation. So he admitted that. And then he says to me, Now remember, he's talking to me as the defendant, representing the defendant. This is not our case. We're being sued, right? That's what this is.
Yeah.
He says that he says, given this situation, he would highly suggest that the government, the Council of Regency, provide a formal invitation to the United States to join in the arbitration. The only entity that is able to possibly have evidence that Hawaii no longer exists as an independent state would be the United States. But there's no public record of it. So I thought that was a really good idea. So I said, okay, let me talk it over with my legal team.
Right.
And we talked it over and we thought, this is good. I'm going to call the bluff. Call the bluff of the United States. And I shared with Ms. Parks what the conversation I had with the Secretary General. And I went ahead and set up a meeting in Washington, D.C. with the U.S. State Department. And Ms. Parks and I are going to fly up there. And we're going to have a meeting with them. And the government is going to provide that invitation. So we ended up having a conference call meeting with John Crook from the U.S. State Department. He was assigned to address us. And he had all the information regarding what was already submitted to the court. And the first thing he said was, and the Permanent Court of Arbitration accepted this case? And I said, yeah. In fact, it was the Secretary General that recommended that the Council of Regency provide you an opportunity to join in the arbitration. And that's when he was quiet. And he started to watch his P's and Q's because I told him, I will be writing I will be reducing our conversation to writing in order to notify the Permanent Court of Arbitration that the invitation was given. After we finished, went to the hotel, I put it in a letter format, and I sent it to John Crook, covering what was discussed, and I carbon copied the Permanent Court of Arbitration. And we came home, and about 2 weeks later, I get a call from the Deputy Secretary General of the Permanent Court of Arbitration. Her name is Phyllis Hamilton. And this was late March of 2000. And she says that they got word from the Embassy of the United States in the Netherlands in response to the invitation. And they respectfully, she said, denied the invitation, but wanted to provide a counteroffer. Could they have access of all records and pleadings of these proceedings? And I said, absolutely. And then later, Ms. Parks consented as well on behalf of Lance Larsen. Now, here's the significance right here. The United States was provided full notice of these proceedings and that the Permanent Court of Arbitration has accepted the case, and we're waiting for them. By them stating a request to have access to other records and pleadings, they're asking permission from the Council of Regency, a government. They're acknowledging us. And they're also acknowledging the dispute that's going on, but they don't want to participate. And that is significant because if Hawaii was really a part of the United States, like everybody believes, the United States would have told the Permanent Court of Arbitration to stop, cease and desist, because Hawaii is a part of the United States and we do not consent to what's going on. But there's no proof that Hawaii is a part of the United States. Because it isn't. So you can see how calling this bluff really got them worked up because they realized there is no evidence that Hawaii is a part of the United States. It's just that everybody has been led to believe it. All of us. So that's when the Permanent Court of Arbitration began to establish the tribunal. And that's when 3 arbitrators were selected, right, with our consent. And then oral hearings were held in December of 2000, okay, just after summer. Now, here we have what is called institutional jurisdiction, and that already has been verified by the Permanent Court of Arbitration. So for our purposes, the Council of Regency, we can now move to phase 2. We got verification under phase 1. Now, in these proceedings, Lance Larsen had to deal with a procedural problem, and it's called what is called the indispensable third party rule. What that means is for an international tribunal to look at the actions or allegations made against a country, that country has to be present to answer those allegations because of sovereignty, right? So the question would be, how can the United States justify the imposition of American law within the territory of the Hawaiian Kingdom? It wasn't about whether or not the Hawaiian Kingdom exists. It was about how can they justify it. Now, Lance Larsen was put in jail and received an unfair trial because of the imposition of these laws through the state of Hawaii. That responsibility is with the United States. That's why the Permanent Court of Arbitration Secretary General asked if I could provide an invitation to the United States to join in. Meaning I'm doing a favor for Lance Larsen. Now, we didn't have to do that because, remember, we're not going to try to help them on this to sue us.
Yeah, sure.
But we were very sure that we were not liable. We acknowledge we're responsible, but we're not liable. And we have been doing things to address that responsibility, and that's called education. So the hearing came up December, 3 days of hearings, December 7th, 8th, and 11th, Thursday, Friday, and a Monday. So Lance Larsen's attorney was the first to go on Thursday, and we would follow on Friday, and then both parties on Monday. And when we are going to do our part, our pleading, our oral argument, we're not going to try to argue that Lance Larsen can proceed to sue us without the United States. Those are rules that are outside of our control. That's an international procedural rule. But what we're going to do, though, we're going to use that as an opportunity to expose Hawaii's occupation. And that's where we had a PowerPoint presentation. We had the treaties up. We were showcasing Hawaii to the whole world. That was part of our phase 2. And we're still defending ourselves, but not saying, oh, Lance Larsen can still sue us. Well, the indispensable third-party rule was a rule. And we quickly knew Lance Larsen, his counsel could not get around it, that he wouldn't able to maintain his suit against us unless the United States was a participant. And after the third day of the hearing, it was clear. We saw that. We won the case. Okay. But then we get a call from the Rwandan ambassador who was at the court attending another hearing at the International Court of Justice. They're all housed in the same building, the Peace Palace. And this Rwandan ambassador, Dr. Bill Zagara, was assigned to the Rwandan embassy in Brussels, Belgium. He was in The Hague at this hearing dealing with genocide between Congo, allegations made by Belgium against Congo. Okay, that the Minister of Foreign Affairs was alleged to have been committing war crimes. Not war crimes, alleged to have been committing genocide. This Rwandan ambassador was Tutsi from Rwanda. He was a Tutsi survivor. He was a survivor of the genocide itself. So that's why he was there. And he heard about our case and was able to access the records because we made it not only public for the United States, but for all countries. Here, look at our country. We've been occupied for over a century. And he told us he had important information to convey to us, and if we could meet him in Brussels. So we caught the train on Tuesday, the day after the hearing, the last day of the hearing, and we're picked up by a motorcade from the Rwandan embassy, taken for a meeting with the ambassador. And the ambassador tells me, and I have my legal team behind me, he says, it is clear that Hawaii is occupied and that he has been in communication with his government in Kigali and that this cannot be tolerated. And that Rwanda is prepared, with the consent of the Council of Regency, they're prepared to report to the United Nations General Assembly, put us on the agenda about Hawaii's occupation. And I'm sitting there in front of the ambassador and kind of taken aback because we're about to move from one mountain to another mountain. And all of our people back home have no clue what's going on. They think it's about a sovereignty issue. They think it's about Native Hawaiians. They think, no, this is about a country. And I said, Your Excellency, I need to have a meeting with my legal team before we can give you an answer. So we had a short meeting. I sat back down in front of the ambassador and I conveyed to him I say, please convey to your president our sincere gratitude, but we cannot accept this offer at this time. Our people back home have no idea of Hawaii status. We need to go home and deal with denationalization. We need to deal with the brainwashing that has taken place for over a century. And that is our focus now. And that's within phase 2 called exposure.
Mm-hmm.
And he thanked me, and I thanked him. We gave our salutations. Meeting came to an end. It was decided by the Council of Regency that since I already had my bachelor's degree from the University of Hawaii back in 1987, and I know what they're teaching about Native Hawaiians, colonization, indigenous, that's all wrong. Mm-hmm. I'm going to enter the University of Hawaii Political Science Department as a graduate student, and I'm going to get a master's degree specializing in international relations and then get a PhD. Mm-hmm. And while I'm there, I'm going to go head on with this disinformation that was even being taught by Native Hawaiian academics. And I can tell you, I was not well liked up there.
Sure.
I was talking about turning over the apple cart. I don't destroy people, but I definitely destroy paradigms. I destroy paradigms. So my new weapon is no longer the 155 howitzer or the 105 howitzer. It's called MS Word. It's called academic research. It's called analytical rigor. Precision targeting, targets of opportunity and pre-planned targets. I just changed. I was still a soldier. I'm still a soldier. I still am a soldier. I'm just becoming a better soldier. And and that is when we began to make that change. And that started in 2001. And since then, majority of our focus has been on that. And I can tell you, when you got somebody right in front of me and they see this information, they cannot refute it. They can't, especially from an academic standpoint. Mm-hmm. But behind closed doors, they try to maintain their false narrative because they have been so steeped in it. They get research money to promote this idea of colonization, of nativeness, and Hawaii being a part of the United States and federal recognition. It's all a lie. And that has been where we're going today and where we are today. So the Larsen case, the Larsen case was not pivotal. The Larsen case was a part of the process, right? Mm-hmm. I haven't seen Ninia Parks in years. It's not like we're all friends, but these were legal proceedings. And the thing is, when we were involved with this, we had our own objectives as a Council of Regency because we were a government, and that was our focus, and it is still our focus. And right now, through the education, it's double-edged. See, because we knew that war crimes had been committed for over a century. Oh yeah, war crimes have been committed. Mm-hmm. Now, even though you commit a war crime, that doesn't mean you can be prosecuted for it. You have to have what is called mens rea. You have to have the guilty mind, right? That's what makes it a crime. Otherwise, it's a civil issue. One of the primary elements that has to be fulfilled in order to have mens rea is you have to have awareness of the circumstances of the facts that establish an occupation. You have to have an awareness. So when you learn this in college, guess what? You've just fulfilled that awareness element. Now, if you're like Judge Sandra Schutte and you do what is called an unfair trial, now you can be held criminally liable. Back then, when Sandra Schutte did what she did to Lance Larsen, I can't say she had mens rea because she didn't know. She was brainwashed, like all of us. But if she did what she did to Lance Larsen today, and everybody knows she knows, okay, that's a different issue. So that's why the Council of Regency is now moving into what is called liability and responsibility for acts. So that's kind of where everything's at right now, and we're still part of this exposure. I just gave a guest lecture at Boston University's Party's School of Global Studies on international relations. And you had some faculty members sitting in, and we had a meeting after the class. They couldn't believe it. They couldn't believe it. They're like, wow, But one of the students, it was amazing. And one of the students in the class it was a Zoom class. She was zooming in from Kuwait. She was Kuwaiti. And she saw the correlations, and she was taken aback. So it's so interesting, but also so fulfilling to see people get it.
As Dr. Sai mentioned, Larsen versus the Hawaiian Kingdom is only one small part of this still developing story, and unfortunately we don't have time to cover every single aspect of it. Nevertheless, I do want to share with you just one last segment from our conversation.
So we have to address over 100 years of denationalization. So just as they weaponized education in a negative way back in the early 1900s to brainwash people, we're going to recognize the potential of education and weaponize it in a good way. We're going to reverse it. And that's how it works. And, our crowning jewel, the Council of Regency's crowning jewel was in 2017, where the Hawaii State Teachers Association, they sent delegates to attend the National Education Association's conference. Now, the National Education Association is the largest union of school teachers across the United States. Okay, National Education Association. The Hawaii State Teachers Association is an affiliate union within that organization. Okay. Well, they introduced a resolution in 2017 at the annual conference in Boston, Massachusetts, and it basically said that the NEA will publish an article on the illegal overthrow of the Hawaiian monarchy, the illegal occupation of the Hawaiian Kingdom by the United States, and the harmful effects the occupation has had on the Hawaiian people. And they passed it. They passed it. Delegates from all over America, they voted, they passed it. Amazing. Those delegates came home, and these delegates are taking classes at the university. They're taking our classes. That's why they're teaching it in the school now. And when they got home, and I was contacted, and they asked if I could write those articles for them to be published by the NEA. And I did. So 3 articles are written. The first one was published in April, I believe, of 2018 on the National Education's website. And it is the illegal overthrow of the Hawaiian Kingdom government. Notice I didn't just say Hawaiian Kingdom, not the Hawaiian Kingdom government. And then the second article came out on the occupation of the Hawaiian Kingdom. And then the third article came out, and that was the harmful effects, where it addressed denationalization and how it occurred in the schools throughout Hawaii. This is the National Education Association putting it out there. That was our crowning jewel. That was huge. And that didn't come because we were playing politics to get them to do it. This came out of delegates on their own, and they did what they did. That's no different than what Lance Larsen did. He didn't do it because he was consulting with us, and we kind of recommended, hey, why don't you try it this way? No. He was just doing it because he was following the rules, and that's exactly what the delegates did from the Hawaii State Teachers Association. So that's when you know that education is now, it's being owned by people. They're not just saying, oh, Dr. Sai said. They're saying, no, what happened in 1893 was illegal, and what was overthrown was the government, not the country. That's important.
For more information about the acting government of the Hawaiian Kingdom and the work of the Council of Regency, visit hawaiiankingdom.org. You can also find a variety of links and videos in the show notes to this episode. Transmissions from Hawaii is a production of Wasabi Magazine. It's produced in the beautiful city of Honolulu by me, Tony Vega. We are now uploading our episodes to the Transmissions from Hawaii YouTube channel, so if you prefer to listen on YouTube, you can find it there. Make sure to hit the subscribe button. And if you're listening in a podcast app, then please remember to subscribe and rate and review and tell a friend about the show. If you enjoy what we're doing here, if you like the stories that we're bringing you, then please let us know and let others know. That will help us make this show something that we can keep on doing over the long term, because it's not easy producing these shows and it does cost money, and we need your support in order to do that. So please remember to subscribe and spread the word about the show. Mahalo for listening, and see you next time on Transmissions from Hawaii.